Welcome to the Georgia Municipal Association's presentation on the Fair Labor Standards Act. I'm Susan Moore, General Counsel for the Georgia Municipal Association. Please be aware that this presentation is for general information purposes only and is not intended as legal advice. Please consult with your city attorney before taking any action based on the information in this presentation. This presentation will be in three parts. The first part will cover employee versus independent contractor, minimum wage, overtime. The second part will cover exemptions from overtime, including executive, administrative, professional, and highly compensated employees, as well as special rules for law enforcement and firefighters. The third part will cover compensatory time, record keeping. First, we'll start with a little history about the Fair Labor Standards Act. The Fair Labor Standards Act was enacted in 1938 during the height of the Depression with the purpose of ensuring that workers were paid a minimum livable wage and to encourage employers to hire more workers by making overtime work more expensive. With the U.S. Supreme Court decision in Garcia v. San Antonio Metro Transit Authority in 1985, the law became settled that the FLSA applied to state and local governments. In 2004, the U.S. Department of Labor issued new regulations revising the salary amount required to be exempt from overtime, established a new test for highly compensated employees, and changed some of the duties required for exemption. Prior to those changes in 2004, the duties test had remained largely the same since 1949, and the last major revisions to the salary basis test were in 1954. The minimum salary level for exemption from overtime had increased in 1940, 1949, 1958, 1963, 1970, and 1975. Major groups who are not covered by the Fair Labor Standards Act minimum wage and overtime requirements include elected officials, volunteers, and independent contractors. The test of whether someone is an independent contractor is based on the economic realities of their relationship to the employer. Are the services rendered by the independent contractor integral to the employer's business? How much control does the employer exert over the individual? This looks at issues such as work hours and workplace. Does the individual have an opportunity for profit or loss? Has the individual invested in the business? Is the working relationship exclusive or long-term? Does the individual have other customers? And how much skill is required to perform the work? This is a totality of the circumstances test. It is not a test where if you answer yes to one portion of the test, that the person is considered an employee versus independent contractor. Rather, each part must be looked at for each different independent contractor and the relationship with the employer. The current minimum wage is $7.25 an hour. A work week is any established consecutive set of 168 hours, basically 7 days for 24 hours each. The work week is set by the employer, and it could be Sunday to Saturday, it could be Monday to Sunday, or any other variation on 7 days. Unless employees are paid weekly, the work week and the pay period are separate things. For non-exempt employees, the employer must pay for all hours actually worked. What counts as hours actually worked? Holidays? No, they do not count as hours actually worked. Sick leave? No. Other leave may count as hours worked. Jury duty, for instance, may count as hours worked. Lunch or other breaks. The question here is whether the employee is free to use that time or whether they are required to work during that time or are interrupted during that time sufficient so that it should be counted as work. Training. It counts as work time if it is for the benefit of the employer. Travel. It counts as work time if it is to perform work for the employer. Commuting time does not count as work time. It is up to the employer to establish in their policies how they will treat each of these examples. Under the federal law, again, holidays and sick leave do not have to be counted as hours worked. If the employer chooses to count those as hours worked, that is a policy decision of the employer and is not required by federal law. Straight time equals the regular hourly rate of pay. Even salaried employees may be eligible for overtime. The regular hourly rate of pay for a salaried employee is the salary divided by the number of hours of work that the salary is intended to cover. Overtime is 1.5 times the straight time pay. Under federal law, it is owed for all hours over 40 worked in a work week. Myth: all employees paid a salary are exempt from overtime. This is not true. Non-exempt employees may be paid on an hourly basis or a salary basis. The truth is that exemption requires 3 things: the salary level, and payment on a salary basis, and the requisite job duties. All 3 of these must be met for an employee to be exempt from the overtime requirements. Employees are eligible for overtime unless covered by an exemption. Again, the 3-part test for exemption is the payment of the salary amount, paid on a salary basis, and the actual job duties performed by the employee. Job titles, job descriptions are irrelevant. It is the actual job duties performed by the employee which must be evaluated. The amount required for exemption is increasing December 1st, 2016. The current amount is $455 a week, which comes to an annual salary of $23,660 per year. The new amount is $913 per week, which results in an annual amount of $47,476 per year. This amount is and will continue to be indexed to the 40th percentile of full-time salaried workers in the lowest wage census region. This amount will be reset every 3 years, with the first reset in 2020. Additionally, employers can use non-discretionary bonuses or incentive pay to satisfy up to 10% of the salary level, provided such bonus or incentive is paid out on a quarterly or more frequent basis. Examples of the types of bonuses or incentive pay available in the public sector would include shift differentials, additional pay for holiday work, or hazard pay. Payment on a salary basis. Payment is received on a salary basis if the employee receives each pay period a predetermined amount that is not subject to reduction because of variations in the quality or quantity of work. For employees of public agencies, deductions may be made for absences under a system where the employee accrues personal and sick leave. Deductions of a full day or less are permitted when leave has been requested and denied, or accrued leave has been exhausted, or the employee chooses to use leave without pay, or the employee is absent due to a budget-required furlough. Again, these are all deductions that may be made from the salary basis without endangering the exemption of the employee. The employer is not required to make these deductions, but is permitted to.